Hello and welcome to Amended California Fair Employment and Housing Act Regulations, what you need to know for April 1st. My name is Jeffrey Hull, Senior Director of Training, and with me today is Mark Nelson, Senior Consultant on Employers Group's Helpline. Today we're going to be talking specifically about the amendments with the Fair Employment and Housing Act that will go into effect on April 1st. Before we move on, we just wanted to reiterate that nothing in this presentation should be construed as rendering legal advice on any particular case. Employers Group is an HR association. We provide a variety of different services, which include helpline, training, research and surveys, affirmative action planning, unemployment insurance, recruiting and staffing, and a variety of other services. We offer memberships and discounts to our members, and we invite you to email us at service1@employersgroup.com for more information on becoming a member, or if you currently are a member and are interested in any of these services. Today's agenda will encompass 3 items: what you must do immediately, how will things change for human resources, and what's coming next with the Fair Employment and Housing Act amendments. There are 2 time frames that must be met. One is April 1st and the other is July 1st. Everything we will be discussing today has to do with the April 1st deadline. Concerning the Fair Employment and Housing Act amendments, there are basically 5 things that you must do. The first is to update your harassment policy. We'll be giving specific advice on that. Updating your harassment training and making sure that it's compliant. We'll be giving you bullet points for that. Review your hiring procedures, revise accommodations procedures, and update your PDL notices. With that, we're going to first touch on updating your harassment policy, and I'm going to turn that over to Mark Nelson to cover that particular area.
Thank you, Jeff. I appreciate it. With these new FEHA amended regulations, we now have some concern with regard to compliance with the written harassment policy. A little background, it's always been, at least for the last several years, a good idea for employers to have a written sexual harassment policy, at least since a pair of Supreme Court decisions back in 1998, specifically Farragher and Ellerith, which gave employers additional protections if they had an established harassment prevention policy, certainly to include a written one. New regulations, however, actually now mandate a written policy with 10 specific requirements. And then there are additional requirements on top of that with regard to the obligation to translate the policy into another language and how it must be disseminated to your employees. With regard to that policy specifically, those 10 points that we must include in our harassment prevention policy, the first one would be that it must be in writing. It's no longer permissible for employers to simply have a harassment prevention program that's just disseminated via instruction. You must have a written prevention policy plan. The second point, you must include all protected classes by name. We've provided the current list as of April 2016 regarding what those classes specifically are. Not a bad idea as a best practice, even in light of this obligation to delineate each and every individual protected class, to also include that umbrella language at the end and any other state, federal, and municipal or local protected classes or classes protected by law, simply because the landscape with regard to EEO is constantly evolving. With regard to the third element here on our page, the last one here, it also prohibits coworkers and third parties as well as supervisors and managers with whom employees come into contact from engaging in conduct prohibited by the Fair Employment and Housing. Given personal liability in California, it's absolutely incumbent upon employers to indicate as much in their written policy. Moving on, with regard to a fourth element here, now we are 4 of 10, it must have a written complaint procedure with all of the following elements. It must have an employer's designation of confidentiality. Interesting point here, and we'll cover it later. They actually do double duty both in this complaint procedure as well as subsequently to the obligation employers have to communicate that they will keep matters confidential to the extent practicable or possible, meaning it's never possible for employers to assure absolute confidentiality because in the course of investigating, it may be necessary to put people in the room so that in terms of giving people enough context to defend their positions, they may necessarily know that somebody else has already said something about them. So to the extent possible is an important qualifier there. In addition, timely response. Of course, that goes without saying, but certainly in the past, there have been problems with employers delaying the investigation for some time. So timely response would be an essential piece of it. Also, impartial and timely investigations by qualified personnel. You should be training your HR staff to conduct workplace investigations or whomever else would conduct it. Documentation and tracking for reasonable progress. Certainly that's important so that we can show that we are in fact moving forward with the investigation. Obviously it's in your best interest to get it done as soon as possible, and it may seem like a little surplus to have to do the documentation and tracking, but certainly have a tickler or some sort of sheet that indicates your progress towards completion. Appropriate options for remedial actions and resolutions. Certainly you want to detail not with a specific rigid step discipline procedure how you will respond in these cases, but showing the spectrum of options available to the employer to include warnings all the way up to termination would be the way to go there. And then finally, timely disclosures, or excuse me, timely closures of the investigation. So that kind of goes with the timely response. Not letting, after the investigation is done, everything dangle out there without final resolution to the investigation. So certainly, once you've taken all the witness statements, you are not off the hook. Make your decisions and close the case. Moving on here, we are on the fifth element. Complaint mechanisms that do not require employees to complain directly to the immediate supervisor, including but not limited to. This is an important piece of it because often it's the employee who wants to allege harassment or discrimination by the immediate supervisor. And if the immediate supervisor is the only one to whom they can go, it defeats the purpose. And it's as if they have no option to complain at all. So you may certainly have as an option, please bring the complaint to your supervisor's attention, but you should also include additional options as well to encompass direct communication with a designated representative like Human Resources, always a great idea. If you're a large enough organization, an EEO officer who's a dedicated EEO investigator, or some other supervisor with whom the employee feels some measure of a level of confidence with. And then moving on down, you could also have a complaint hotline, an ombudsperson, or identification of the Department of Fair Employment and Housing, or EEOC, as additional avenues for employees to go to. I would probably, if I was going to use that last piece of it, I might make sure that my legal counsel was okay with including that in part of the written harassment policy. But certainly have the option for them to approach their supervisor, but if not their supervisor, someone like Human Resources or EEO at the least. Moving on down here to cover these mandatory 10 elements. Another one would be supervisors instructed to report any complaints of misconduct to a designated company representative, such as Human Resources, so the company can resolve the claim internally. You want, obviously, the first stab at it so that the individual does not run directly to the EEOC or DFEH. Another element here that's mandated by these regulations, when allegations of misconduct are received, the employer will conduct a fair, timely, and thorough investigation that provides all parties appropriate due process and reaches reasonable conclusions based on the evidence collected. This is just basically stating kind of the due process piece of it. So you want to make sure that you are taking in consideration when establishing your complaint procedures all of these factors. Moving on down here, and I said this would be, we're doing kind of double duty with this obligation for confidentiality, but again, we're repeating what we said earlier in your complaint procedure, a statement directly to the employee that confidentiality will be kept to the extent possible, but indicate that investigations cannot be completely confidential. And then, of course, another element here, if at the end of the investigation misconduct is found, that you took appropriate remedial action. And then finally, employees shall not be exposed to retaliation or lodging complaints or participating in any workplace investigation. This is absolutely essential. You should have these anti-retaliation provisions in virtually any complaint procedure, but certainly in harassment. Employees need not succeed on the initial complaint against the individual regarding harassment or discrimination to succeed on a retaliation claim. These retaliation claims are hot topics. Do not set yourself up for one by failing to include it in this written harassment prevention policy. With regard to the harassment policy, like we said, in addition to the 10 mandated factors or elements of your written harassment prevention policy, you must also consider translation of that policy if 10% of the employer's workforce speaks a language other than English. In other words, a policy must be translated to each language spoken by at least 10% of the workforce. That's obviously a very significant consideration here in California with so many multilingual communities. Moving on, with regard to the dissemination of the harassment policy itself, employers must use one or more of the following methods to disseminate policy. Certainly the most traditional one would be to print and provide a copy with an acknowledgement form, the acknowledgement form being an essential element of that. Also, we're seeing more frequently sending the policy out via email, and of course, again, requiring an acknowledgement form be returned. You could also, as another option, post the policy on your company intranet with a tracking system to ensure everyone has reviewed it. Or you could discuss the policies during new hire orientation. Obviously, the problem with that is that it's not going to capture all the existing employees. And when you update your written harassment prevention policy, you want everyone to have signed off on it. So this would just be an additional option, but I would not consider it the only option in this list. And then finally, the umbrella statement of any other way that ensures employees comprehend. I would consider that to be something like having a Q&A as you disseminate the policy in an all-employee meeting or something along those lines. But I would consider elemental one or two, the first or second option here, and certainly additional options after it. Perhaps even if you have a way to track via the intranet, that might be another replacement option for 1 and 2. But that being said, I would probably recommend considering employers consider offering multiple forms of dissemination. And with that, I will hand it back to Jeff.
Great, thanks, Mark. Appreciate that. And a lot of what the new regulations stipulate basically tie in training to policies, and it really cleans up the past amendments with the acts and really makes it more comprehensive as far as what employers should be doing and giving specific guidance. So a lot of what Mark's policy guidance will basically point to is compliant training that really is consistent with the policy items that Mark just outlined. It's also important to note that in California, any employer with over 50 employees must provide harassment prevention training to all supervisory staff. So that is a state law that those employers must comply with. It's important to note as well that the policy requirements that Mark just went over Having a compliant policy is required for employers with 5 or more employees. So that's a really important distinction. Certainly the best advice is for all employers to not only have a compliant policy, but also to have compliant training. So in this portion, we're going to be talking a little bit about harassment prevention training, and the state has already given guidance to employers on what should be included in their AB 1825 training. And so we've listed all the items that need to be in a training program. So this is sort of your tick list on what you should be looking for in the training program and ensuring that it is provided to employees, which is consistent with the policy requirements. Here we've listed everything, but in the right you'll see parentheses which identify the new revisions or new requirements regarding what should be in your harassment training program. The very first is how to identify unlawful conduct, and that really needs to identify what constitutes harassment, discrimination, or retaliation under both the Fair Employment and Housing Act and Title VII of the federal laws. The next item is what Mark had indicated earlier, the supervisor's obligation to report behavior that may be construed as harassing. So that is now a requirement in the training program. Just like it has a policy requirement, it now requires employers to report behavior that might be viewed as harassment or discrimination. The next item are listed here. The new one is providing information related to the negative effects of abusive conduct. As we all know, that was added as a new law about 2 years ago in California, and this change in law or in change in the regulations stipulates that abusive conduct needs to be conducted in the training program. It's notable to state that in the policy requirements, you'll note that there were no inflections of abusive conduct that need to be put into the policy. So this is something that goes beyond the policy on just having a more respectful workplace and to avoid abusive conduct. So it does require that the trainer or training program go over the negative effects of abusive conduct. The next one that has been revised is developing and encouraging a set of values to assist in preventing and effectively responding and implement mechanisms to promptly address and correct wrongful behavior. And that is consistent with the policy requirements. So once again, it points directly to the policy. So in essence, when you're conducting training, you're basically reinforcing all of the policy requirements and policies and procedures that your company has already implemented and discussed. The next one regarding revised training content, the very first one, very last one is the revision. And this specifically points to the remedies that are available in civil cases. And there's not a tremendous amount of cases where somebody has been sued individually for harassing behavior, but the new regulations do have significant references to the personal liability from harassing behavior. So it really reinforces that policy component, and that really reinforces what needs to be discussed in training on the remedies that would be available in civil cases. For the revised training content, the other item that is new and it directly correlates to what Morgan said earlier is the supervisor's obligation to report known harassment. So this prevents supervisors from trying to take on and maybe handle a harassment situation on their own, which of course we never advocate for. So this makes it clear to the supervisor that they're obligated to report harassing behavior or a complaint to human resources. So that is actually a welcome change to the regulations. The other items that are changing are the steps necessary to correct harassing behavior, such as through investigations. Also, that can point to other remedial steps that you might need to take to stop harassing behavior or make an employee feel safe if they feel unsafe because of harassing or abusive conduct. So that also needs to be incorporated into a training program. The final item is regarding abusive conduct. And with abusive conduct, because that is fairly new, the state has not given prior information on really how that should be addressed in a training program. So this specifically identifies the negative effects on the victim and others, which I spoke about briefly before. The detrimental consequences on the employer, such as reduced morale within the workplace, what the elements of abusive conduct are with malice, etc. And once again, abusive conduct is really, hostile, offensive, and it's unrelated to legitimate business interests. The thing about abusive conduct is it's not tied to a protected characteristic. So abusive conduct can basically be directed at anyone within a company. So, consistent yelling or verbal abuse could be construed as abusive conduct. So certainly those will come to light. So if they do, that can be considered, poor leadership skills. It might not go to illegal conduct, but it could really be consistent with bad leadership skills. So it might necessitate the need for additional training on better leadership skills. And certainly when you update your policy, it's really important to train on that new policy, because a lot of people may not know what the new policy requirements mean for them. So with the new changes, we'd recommend that possibly you think about implementing training programs. And training has many different ways according to the law on what can and which modes can be provided. While we don't have it stated here, there's basically 3 ways that companies can comply with AB 1825. The first is in-person training, where an instructor is actually giving classroom training to a group of individuals. The second is e-learning, and the third is webinar training. For e-learning, the requirements did change in the fact that the trainer must keep all written questions and answers for a 2-year period. So if you are using an e-learning provider, it's important to make sure that they are, in fact, inventorying the questions that they receive and the answers that they provide, and that they pledge to do so for a 2-year period to be compliant with the new requirements. And the next one is changes specifically for the webinars. If you are using webinars, certainly it's not the most effective means of providing training, because it's a very passive experience. So the state back in 2005 actually implemented a lot of requirements, ensuring that each trainee was actively engaged in the training program, and they just simply weren't just watching a screen move through. So so the state will require, if you do use webinars, that they want to see proof that it was interactive. So they require you to keep a copy of that webinar for a 2-year period, so that if a complaint is lodged, they can review that webinar to see if the training was compliant and did meet all of the requirements of the regulations. The state has also given guidance to employers on the retention of records. It's really important that the ultimate compliance with the record keeping is with the employer. It's your responsibility as an employer to maintain all the compliance documentation that you need to support that you've completed compliant training. So your training should include names of all supervisors trained, the dates that they were trained, a sign-in sheet if it's an in-person session. It can also be a completion log if you're in e-learning, if you use e-learning to show that they've completed the training and on what date. The certificates of attendance and that they completed training, that is a new requirement. You can also use something like an acknowledgement form that they acknowledge individually that they've completed the training program. That could suffice as a certificate of attendance. The type of training that was conducted, was it in person, was it webinar, was it e-learning? It's important to note that the type of training that is not compliant is video training. While videos can be incorporated into any of the modes of delivery, just supplying a video for trainees to watch is not a compliant means of conducting the training. So do not rely on just showing a video to comply with the California Fair Employment Housing Act regulations. Making sure that you have a copy of all the written and recorded materials that were in the training program. So if you are doing an in-person session, making sure that you retain a copy of the exact materials that were provided to attendees just for compliance reasons. If you are using an e-learning module, making sure that that module will be available should the state require it to be sent in to them to review whether or not you were compliant. And the next one is the name of your training provider. There is turnover within human resources. So just in case that provider's name is not in your AB 1825 file, making sure that the contact person website, contact information is located in that file. In case you might not be with the organization anymore and they can appropriately contact that training provider. So I wanted to turn it over to Mark to go over the next item, how things will change for human resources.
Thank you, Jeff. So we've talked up till now about immediate changes that you should be implementing in response to these new revised regulations for FEHA, but there are additional considerations above and beyond simply the training and the written policy that will also impact how you do things operationally from an HR perspective. A few things we'll talk about today would be how it'll be necessary for you to update your diversity training to include some new definitions that were supplied by the agency. Additionally, you'll want to make sure that your accommodation procedures, if you have a policies and procedures manual, for example, that it includes discussions that the DFEH considers important in light of religious and disability accommodation process. Additionally, you will want, for leaves administration purposes, to update pregnancy disability leave procedures. And finally, in light of the new AB 60 legislation that allows or permits individuals who are undocumented to have driver's licenses, you will want to make sure that your hiring managers are aware of some changes there. Let's move on. And with regard to the diversity training specifically, by way of background, the Fair Employment and Housing Act already protects individuals on the basis of sex, gender identity, gender expression, and sex stereotyping, but the regulations lack some definitional clarification. So what they did with these amended regulations is provide that definitional clarification. We'll dive right in and kind of look over what those are. With regard to the definition of sex, the Fair Employment and Housing Act, the statute itself already has these definitional pieces to them. So basically what the regulations are doing are just simply reiterating what the statute already says. So for purposes of sex discrimination, ensure that your diversity training encompasses under sex not just pregnancy, but also related medical conditions, childbirth and the same, breastfeeding and the same, i.e. related medical conditions, and also within sex, we consider not just the biology of sex, but the social component of it in the form of gender, and also under that category, gender identity and gender expression, which we'll cover in slides coming up here to provide definitional clarity for both of those as well. Please also note that under the definition of sex, the regulations also indicate that it's not a defense to harassment, that the harassing conduct was not based on sexual desire. In fact, it's almost more a power play anyway. So employees can't say, well, I'm not sexually attracted to that individual.
It's really important to note here as well with updating diversity training is that you do have the diversity and discrimination components within the training that you provide to supervisors under AB 1825 requirements. So it is a best practice to make sure that you do implement or incorporate these types of components into your training program. So that might be something else you might want to watch for.
Great point, Jeff. Absolutely. Absolutely. Wonderful. And then moving on, we've got the definition of gender identity. This was new, so it adds new to the regulations a definition of gender identity to include an individual's identification as male or as female, or as a gender different from the person's sex at birth. It also encompasses transgender, which incidentally is not defined in the statute. So as we'll find out here shortly, the definition that they add of transgender is also helpful in that regard. With regard to that specifically, like we said, transgender, though it's not in the statute, is addressed as a subset of sex, and for that reason, we want to make sure that we understand, or everyone's kind of on the same page with regard to the terminology used. And transgender refers to a person whose gender identity differs from that person's sex at birth. It may or may not, the individual may or may not have a gender expression that is different from the social expectations of the sex assigned at birth, and that individual may or may not identify as transsexual. So transgender being the umbrella term here. It also cross-references FEHA's existing definition of gender expression. In other words, the previous two were new definitions that were offered up to explain statutory language, but gender expression was always itself defined in the statute, and that would be the person's gender-related appearance or behavior, whether or not stereotypically associated with the person's sex at birth. Important to have these definitions lined out, so when you conduct the training, inevitably there will be questions from your participants regarding what the terms of these classifications mean. So ensuring that you have what the Department of Fair Employment and Housing considers important is certainly key. Please also note that we are already well aware of sex stereotyping. It's essentially the incorrect assumptions that individuals have about people based on gender assumptions or stereotyping, but it need not only be about that individual's abilities, it can also be about their appearance or behavior. Assumptions may be based not just on myths and generalizations, but also social expectations. It's, the stereotype of the female employee being more nurturing, and if she's not filling her gender roles, and individuals calling her out for that, that is an example of sex stereotyping, and it's not permissible, excuse me. With regard to moving on from diversity training to accommodations and updating your accommodations procedures. When we think of accommodations, by the way, what we're generally thinking about with reasonable accommodations is religious accommodations and disability accommodations. Those are the two protected class statuses that with them come obligations for the employer to engage in the interactive process if an employee makes a request for a reasonable accommodation. Please note here, the Fair Employment and Housing Act regulations already address both religious and disability accommodations, but these new regulations clarify some new developments in accommodation practices. With regard to religious accommodations, it clarifies that it's not a reasonable accommodation for an employer to segregate an employee from customers or the general public. I would hope that would go without saying, but please note it is an important one. It also prohibits employers from retaliating against individuals who made the request, even if you could not afford that individual the religious accommodation. In other words, the employee made a request for a religious accommodation. You could not find a reasonable accommodation for them and declined it. You cannot say that you're not retaliating against them thereafter. They're simply making the request for the accommodation can trigger a retaliation claim, so to speak. Moving on, with regard to disability accommodations, it adds a new regulatory component here. that being support animals. When we think of animals in the workplace, we generally think of assistive animals like guide dogs or service dogs. That is not what a support animal is. A support animal, by definition here, is one who provides emotional, cognitive, or other support for an individual. Take, for example, a victim of PTSD. The calming effect that an animal can have on their emotional state could be a reasonable accommodation, even though that support animal may not be providing other services like those you would expect of a guide dog or service dog. Just having the animal there as a calming presence. In addition, we have, with regard, the same with disability law, by the way, is you cannot retaliate against someone just like you can't in religious accommodations, even if you could not find an accommodation for them. So important piece of that as well. Moving from the diversity training through accommodations, now we are on to pregnancy disability leave. Pregnancy disability leave, of course, we had sweeping changes back in 2012 to the regulations just a few years ago. So really what we've got here are some cleanup issues and minor changes only to reflect new developments in that thinking. It adds clarification for coverage purposes. Pregnancy disability leave is extended to transgendered individuals who are disabled by their pregnancy. Just by way of clarification, that I would hope you would already be affording that anyway, and also it consolidates notices. It eliminates Notice B and consolidates language from Notice B in a single notice and removes the title Notice A to it. Incidentally, the Department of Fair Employment and Housing on their publications is still referencing Notice A and B despite these regulations taking them out. And please also notice that your obligations with regard to give the notice for pregnancy disability leave, if you are a CFRA employer, in other words, if you employ 50 or more employees, you may still have additional obligations for posting and notices under the CFRA, which we'll be addressing when the CFRA regulations effective July 1 we'll be providing a separate update of those changes later. With regard to hiring procedures, please note, as we mentioned briefly before, AB 60 was passed permitting licenses for undocumented individuals. The new regulations incorporate AB 60 considerations into effect. More specifically, and moving on, they incorporate these prohibitions. You may not discriminate against individuals because they possess a license issued under AB 60. You can only additionally require driver's licenses if it's required by state or federal law, or alternatively, if it's required by the employer as policy, like for employees who would drive for you, and it's otherwise lawful for you to do so. Inconsistent treatment, by the way, may set up a claim targeting protected classes for clarification of driver's licenses, but not requiring driver's licenses of other individuals. That can be problematic. Additionally, please note, if you're wondering, well, what about the driver's license and using AB 60 for employment eligibility purposes? Remember, under the I-9, you must prove both identity and employment eligibility. There are different lists that show how you're using that document. A List A document is one that proves not just identity, but also employment eligibility, because it has both a picture and your status as employment eligible in the same document, like a passport. There are also List B and List C, which one document proves only identity, while the other document proves only employment eligibility. Remember, licenses fall in the category of only proving identity because they're issued from a reliable source with your picture, and therefore would identify you as who you are, but you still would require a List C document, or if they wanted to present a List A document, they wouldn't even need the driver's license. So don't get that confused with what we're talking about here. All right, with that, I will hand this back to Jeff to close out our presentation today.
Great, thanks, Mark. And it's really important to know we discussed a laundry list of items that need to be addressed in your policy or your training program. I just want to reiterate that you should make sure that your training provider is compliant with everything that we just discussed. Employers Group does offer training, especially e-learning and instructor-led. Our training programs do incorporate all of these changes. In fact, our harassment training does include all of the items that we discussed today to make sure that you are compliant with the law and your supervisors understand how this applies to them. So that is a really important distinction. There's not a lot of providers that do focus on this. And the other thing that I wanted to reiterate is with the harassment training, while the state does give specific guidance, over 40% of the total complaints made in the U.S. Had to do with race. And, making sure that your training is compliant with what the actual risks are out there. As we all know, sexual harassment complaints that have been going down over the years, just through the sheer nature of providing this type of training. But certainly other types of complaints are now rising. So to keep your pulse on the different aspects of what the complaint landscape looks like. Now, as I said earlier, there's basically two parts: an April 1st deadline and also a July 1st deadline with the amendments that were just approved. So on July 1st, there will be revised CFRA regulations because we wanted to be very consistent with what you need to do now versus what you need to do later. We will be covering that on a special webinar coming up very soon. So if you do want access to that webinar, you can simply email us, and I'll provide the email address in just a little bit. For anyone that's reviewing this webinar, we do have a toolkit available. It does contain all of the items listed on the screen here. And if you do want this toolkit, please contact us, and we'll be happy to send it out to you. And if you do have any questions regarding today's webinar, you would like the toolkit, you would like to sign up for future webinars, or you're interested in any training programs that are compliant, you can call us at 1-800-748-8484, or you can email us at service1@employersgroup.com. We thank you for your time listening to today's recorded webinar, and once again, we hope that we can serve you in the future. Thank you.